a couple days ago. We did a show on birthright citizenship because, of course, Trump has issued an executive order on the notion of birthright citizenship, limiting it to American citizens, the children born on U.S. soil to American citizens, and to permanent resident aliens, but excluding from birthright citizenship under the 14th Amendment people who are visiting the U.S. transiently and bear a child, and people who are illegal, unlawful invaders of our nation. And of course, he's now being sued in federal courts, going all the way to the Supreme Court. Lots of people are filing amicus, friends of the court briefs with SCOTUS. We covered one the other day from a bunch of states, 24 different state attorney generals filing an amicus brief in support of Trump's executive order, appropriately, constitutionally limiting birthright citizenship. And now I have another amicus brief from a group of senators. So President Trump's great battle to preserve American birthright citizenship for Americans and save it from infection, contagion by illegal migrant third world invaders. Well, Trump's battle continues to gain support, this time from a collection of U.S. senators, including Ted Cruz, Mike Lee, Marsha Blackburn, Lindsey Graham, I know, and a bunch of others. And this week they filed an amicus brief with the U.S. Supreme Court arguing for the constitutionally correct position that the 14th Amendment birthright citizenship clause applies only to the children born on American soil to American parents, and perhaps to those born to permanent legal residents, what we would call today green card holders, but that there is no such thing as birthright citizenship for children born on U.S. soil to parents who are transient visitors to the U.S., work visas, student visas, birth tourism visas, and especially no birthright citizenship for children born on U.S. soil to parents who are illegal invaders of our nation. Well, they're United States senators. They have a strong interest in the outcome of this case because Congress, as a co-equal branch of government, has an interest in the courts upholding the Constitution. Specifically, the historical record confirms that the 14th Amendment does not confer citizenship on the children of aliens unlawfully present in the U.S. An alien who seeks political rights as a member of this nation can rightfully obtain them only upon the terms and conditions specified by Congress. Because the lower court's decision, they put a preliminary injunction against Trump's executive order on birthright citizenship, which again, Trump's executive order doesn't actually change anything. It merely recognizes the correct law of birthright citizenship. When you see reporting in the media about this, it's always characterized as Trump trying to change birthright citizenship or do away with birthright citizenship or strip from children born to illegal migrant third world invaders birthright citizenship. Trump's executive order actually changes nothing. It only recognizes the correct constitutional state of birthright citizenship. English law. In Calvin's case, which this Supreme Court cited in Wong Kim Ark, Lord Coke, so that's a British case, not an American case. Lord Coke, a famous British judge, Lord Coke explained what made someone subject to the jurisdiction of English courts. He noted, Ted Cruz probably wrote this, so it's going to be full of Latin, which obviously I don't speak and cannot really pronounce except when it's a legal term of art I'm familiar with. Lord Coke noted that it is nec calum nec solum, neither the climate nor the soil that grants citizenship, but ligentia, allegiance, and obidentia, obedience, that make one subject to the laws of the country. So it's a mental state. It's not an accident of geography or presence. Jurisdiction in that sense does not turn simply on whether the person was present within the territory or subject to its laws, like criminal law, but whether he owed allegiance to the sovereign. As the D.C. Circuit has explained, Calvin's case means those born within the king's domain and within the obedience or allegiance of the king were subjects of the king or citizens in modern parlance. Lord Coke cited several prior cases to make the point. Most notably was Perkin Warbeck's case, where a Dutchman declared himself the rightful heir to the English throne, then traveled to England in an attempt to take the throne. He was captured, But the English court concluded he could not be punished by the common law for treason because he was not subject to the civil court's jurisdiction. It's only treason if you're acting against your own nation. There was no state of war between the countries, but his mere presence was unlawful, and thus he had never been under the protection of the king, nor ever owed any manner of allegiance to him. As Professor Estreicher, an expert on these issues, a legal expert, explains, Warbucks' very setting foot on the English soil as a pretender to the throne made him a criminal in the eyes of English law, one who had never claimed the protection of the king by virtue of his lawful presence in the realm. So it was the illegality of his presence that placed him outside the ordinary jurisdiction of English law. What about the understanding of citizenship during the drafting of the 14th Amendment? The concept that jurisdiction included two aspects, being subject to a nation's laws, like criminal law, but also holding allegiance to the sovereign, continued into international relations and American practice in the lead-up to the 14th Amendment. The status of dual allegiance, ordinary as it seems today, seemed anomalous and inappropriate in the 1860s, as the general view was that no one can have two countries. And by the way, I don't know why that's not the rule today. I don't know why we allow dual citizenship. I've mentioned in the past, I've had the opportunities for dual citizenship in two nations, European nations, Belgium, where my mother came from, and Italy, where my father's side of the family came from. And I've never done it, even though it would have had certain employment and other advantages, working within the EU, for example, which I did for a number of years. It would have obviated the need for me to have a work visa in the EU, which I had to arrange. But I never wanted to be in a position where my loyalty to America could be contested as being split. At the time of the 14th Amendment's drafting and ratification, the terms immigration status would have been meaningless because the United States had only minimal immigration laws in the modern sense. And instead, the crucial inquiry was the parent's allegiance to a foreign country. That's because the general rule at the time was that citizenship of a child followed the parent's citizenship, and their original sovereign would often claim the allegiance of the child regardless of where he was born, as British law at the time plainly did. United States law was the same. In 1855, before the Civil War, Congress enacted a law dictating that persons heretofore born or hereafter to be born out of the limits and jurisdiction of the United States, whose fathers were or shall be at the time of their birth citizens of the U.S., shall be deemed and considered and are hereby declared to be citizens of the United States, except for persons whose fathers never resided in the U.S. Accordingly, in 1866, a foreigner could be domiciled in the United States, but remain subject to a foreign power, a foreign national. With this background, the terminology used by the drafters of the Jurisdiction Clause makes more sense to modern readers. The history of the Jurisdiction Clause begins with the Civil Rights Act of 1866, which stated that all persons born in the United States and not subject to any foreign power are hereby declared to be citizens of the United States. So this was the first effort, the Civil Rights Act of 1866, to grant citizenship to the freed black slaves in statute form. Senator John Bingham, a principal author of the future 14th Amendment, said this provision meant that every human being born within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty, as the freed black slaves didn't because they had no state, they were stateless, but a foreign national would. Every human being born in the jurisdiction of the United States of parents not owing allegiance to any foreign sovereign would be a citizen. This invoked the concept of total allegiance to the United States, a concept defeated if the parents, and thus their child, owed any allegiance to their home country. There were, however, serious doubts whether Congress had constitutional authority to enact the 1866 Act. President Andrew Johnson vetoed it in part on that basis, but the veto was overridden. And so it was clear to many in the Republican majority that a constitutional amendment would be needed to give the Civil Rights Act a solid foundation on which to survive future legal challenges. Accordingly, it cannot be seriously doubted that what would become the jurisdiction clause was intended to have the exact same meaning as the Civil Rights Act of 1866, which referred to foreign allegiance. The earliest draft of the 14th Amendment originally included no citizenship clause. But in May 1866, Senator Benjamin Wade sought to replace the word citizen in the privileges or immunity clause of the 14th Amendment with the phrase, persons born in the United States are naturalized by the laws thereof. This prompted a discussion of whether that was actually the proper definition of citizen. Senator Jacob Howard, a sponsor of the 14th Amendment, soon proposed a new clause that invoked the historic term of art jurisdiction. All persons born in the U.S. and subject to the jurisdiction thereof are citizens of the United States. Importantly, that same Senator Howard explained this will not, of course, include persons born in the United States who are foreigners, who are aliens, who belong to the families of ambassadors or foreign ministers, but will include every other class of persons, like freed black slaves, who under prior Supreme Court precedent, the Dred Scott case, had been determined by the Supreme Court that freed black slaves were not American citizens. That's part of what this was all intending to address. This express reference to alien suggests that even the drafter did not believe it would apply only narrowly to children of ambassadors who were listed as a separate category excluded from birthright citizenship. The primary focus of debate during this time was whether the jurisdiction clause would extend to Native American Indians. Senator Edgar Cohen noted, "It is perfectly clear that the mere fact that a man is born in the country has not heretofore entitled him to the right to exercise political power, citizenship. Sojourners or travelers, for example, have a right to the protection of the criminal laws, but he is not a citizen in the ordinary acceptance of the word. The right to protection of the laws invoked the narrower sense of jurisdiction, but to become a citizen, something more was required." I'm going to add this because I want to circle back to it after the show. I have some thoughts on those. Senator Lyman Trumbull, who is the chair of the Senate Judiciary Committee and seen as the Senate expert on the closely aligned preceding Civil Rights Act of 1866, was asked what the jurisdiction clause meant in this context. He replied, "What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. The subject to the jurisdiction thereof means subject to the complete jurisdiction thereof. Any divided loyalty meant no citizenship, just as it did in the preceding Civil Rights Act of 1866. Applying that test to Native American Indians was seen as so straightforward that the drafters decided against including an express exception for Indians not taxed, as they had done in the 1866 Act and would also do in Section 2 of the 14th Amendment. Federal law had long applied to Indians, criminal law, but they owed at least partial loyalty to their tribes, and so the jurisdiction clause unambiguously meant the 14th Amendment would not confer citizenship on their children. Congress later granted Indian citizenship via statute. That's that 1924 statute I mentioned earlier. But until that time, the Indians were regarded as alien people residing in the United States and thus were not born in the United States and subject to the jurisdiction thereof within the meaning of the 14th Amendment. As modern scholars have recognized, Senator Trumbull and those who agreed with him spoke of the jurisdiction arising from allegiance. Everyone recognized the narrow form of jurisdiction, not the broader criminal jurisdiction that applies to everybody, but the narrow form of political jurisdiction, meaning entitlement to protection of the laws, criminal law. But it's clear that the men who drafted and passed the Citizenship Clause recognized a second degree of subjection to a country's jurisdiction, a subjection to its complete jurisdiction in ways more closely associated with the rights, duties, and deeply rooted natural allegiance inherent to long-term residence in and meaningful interaction with a particular society. So this is what captures the permanent resident aliens, what today we would call green card holders. It does not capture illegal migrants, even if they've been illegally present in the U.S. for 30 years, because they're here illegally. They have no status. The senators continue, and that more complete form of jurisdiction, political jurisdiction, was needed for citizenship. Merely being born in the United States and being subject to its criminal laws was insufficient. If the parents had divided allegiances, the child would not be a U.S. citizen under the 14th Amendment jurisdiction clause. That approach directly tracked the Civil Rights Act of 1866, which the jurisdiction clause constitutionalized. Recall, that act excluded those who owe allegiance to any foreign sovereignty. That same limitation was carried into the jurisdiction clause, except the latter was stated affirmatively with respect to the U.S., must owe allegiance to the U.S., whereas the Civil Rights Act had been stated negatively with respect to foreign sovereigns, cannot owe allegiance to another sovereign. But they mean the same thing. This is the key legal issue. As noted, the most common example at the time of someone who lacked complete allegiance to the U.S. would have been the children of Native American Indians, but the same rationale that excluded the children of Indians would exclude the children of Europeans born in the United States if the European power involved claimed the allegiance of the child, which most, notably British law at the time, plainly did. Because no one could owe allegiance to two sovereigns at that time, such children could not claim total allegiance to the U.S. and thus would not be citizens under the 14th Amendment, just as they would not be citizens under the Civil Rights Act of 1866. The focus on allegiance continued in the years immediately after the 14th Amendment was ratified.